for IPR that varies from person to person and that varies from institution to institution. There are several ways of looking at the same thing in life. So, I am not sure what the speaker would have talked of when she was here. She would have been here rather. But I have also been to the Global Intellectual Property Academy, which is a part of the United States Patent and Trademark Office, and that tells of the climax in learning related to IPR and communication. So, it is in that context when IP will be talked of and landscapes will be talked of, the canvas is open and you can paint anything that you like. But having told that, we will go by certain fundamentals and certain things which have been fixed at this point of time in relation to landscape. So, it can be a simple view or a panoramic view or a vista, and I mean when we talk of the concept, it can be the entire prospect about that concept or the issue. So, in context of this landscape for IP, the very first thing is about the policies related to intellectual property. First, let me ask you a very plain question. How many of you can differentiate between IP and IPR? Do you know the difference between IP and IPR? Please raise your hands, those who can express what is IP and what is IPR and what is the difference between these two. Anyone? Please.
IP is a creativity of honor.
Yes.
And IPR is it is a right to protect that innovative
Right.
invention.
Okay, very good. But in case you have innovated something, if you have created something with your mind, do you automatically get the IPR or so you don't automatically get? But in any circumstances, do you get somewhere a right? Okay, good. Right. So, you know the basics and that is where we begin with. So, in the landscape, the very first thing is the array of the rights those are available. These are called the standards of IPR as far as the international agreement on the intellectual property, particularly the trade related intellectual property is concerned. So, that array will provide you a landscape of the rights. Those can be available to individuals, whether these are natural persons or these are legal persons, which they can enjoy as private rights exclusively for certain term period in a particular jurisdiction. So, now for that law will express certain things, and how law will express certain things? It is based on the statutes, which are the written versions of individual clauses or individual articles, and not only the legislation means act, but also the subordinate law, that is the rules and the regulations and the administrative orders together, this will be part of the legislation. And not only that, also some of the case laws where some decisions have been held by the courts will also form a part of that landscape. And the third thing in that law that I have written is jurisprudence. And jurisprudence is an area which is the development of law. So, at any point of time, if something is uncovered rather, the law researchers will be sitting on that to work on the nitty-gritties of it to find out how better it can be resolved. On the immediate basis, these will be resolved only with case laws, these particular judgments on particular cases by the judges. But in the long term, when that issue accumulates to certain extent, then someone will have to go back to the legislatures to ask for the amendment of the existing legislation, the existing act, so that that can be internalized as a part of the law. So, now how we interpret the law and how we really practice intellectual property rights application is all what is based on the mindset. And the mindsets can vary based on many things, and particularly two things. One is our own perception, and second is our own capability to handle it, to address it. And within these two basic things, there will be whole lot of certain other issues which will also determine the mindsets. But having said that, this mindset divides the world into two categories broadly, the developed and the developing. The developed ones will have their mindset in favor of IPR, in favor of intellectual property right, and would like to have the intellectual property laws and their practices so stringent, so that there is no loophole, so that they are able to take as much benefit of the exclusivity provided by that law as it would be possible to them. On the other side, the mindset by the developing will be that there should be as much waiting period borrowed as possible, so that they can at least cope up to some extent to get certain returns of their investment compared to their more competitive developed partners. So, all this mindset and law and IP landscape based on the policies, that has no meaning unless until there is innovativeness in minds. So, innovations also provide the landscape. What was available a decade back in the pipeline in one field of technology will be meaningless at this particular point of time, and in future whatever is being developed now will also become meaningless. Abhi busy nahi. So, in that context, innovation is a dynamic process which will help you evolve as the evolution of human societies go side by side. So, these are some of the ingredients of the landscape which I am trying to interact with you. The institutions, the mechanisms, the tools available of that will also be a part which we also will discuss in the course of this lecture. One primary thing in IPR field, if you have done some background studies before coming here, you will see is that whenever we are talking of IPR, the other side will be talking of some escapes in one name or the other, and primarily that escape will be giving a part of the benefit to the society, as if the IPR holder is not committed to give to the society anything, because when the IPR holder is bound by other civil laws, other financial laws, his or her commitment towards the society is fulfilled through those. He is paying the taxes, he is paying the service fee, he is doing his corporate social responsibility, but still the talk will be, no, no, you have not given that part of the benefit that was accrued to someone else. So, that means our mindset is not allowing us to develop in the area of intellectual property right, and precisely to say our mindset is not allowing us to be competitive. Having said that, if we have to understand the basics, one basic is about the answer that she gave, that whereas intellectual property subsists in all creations of mind, right does not necessarily subsist in that. Right is only after you have been given that grant under some law based on your application, subject to certain oppositions. If you have cleared those oppositions and all other necessary prerequisites, only then you have the right. So, very first let in this you can say stanza that is generally used in the judgments in courts is that he who does not have a title in a property cannot transfer the same. So, that means IPR, IP is not IPR. If I am talking of IP landscape, perhaps I am talking of the landscape for the technology development. But if I have to talk of the IPR landscape and talk of the law, the right, so that means he should be very clear about the grant, about its maintenance, about his own role, obligations and duties. So, that means the onus of any infringement does not lie on the government, and this is another lacuna on the mindset of the developing minds or developing economies or developing countries. They think once I have been given the grant, it is the duty of the government to protect me for that. No, you have taken the right by telling the court that you have got an invention which should exclusively belong to you, because you have invested your mind and other resources into it, and until a specific time by which you will be able to recover certain benefits, so that you can plow back that part of the benefit into your further R&D and part of the profits for your economic well-being, you will not be granted that right. So, that means it is a conditional grant, and in that one of the condition is that if there is any infringement, well, there is a legal recourse and a speedy recourse, but the onus is on you to take action, not on someone else. This is one side of intellectual property right, be clear about it in the landscape. The second part is, you have heard of farmers' rights, you have heard of access and benefit sharing, you have heard about traditional knowledge and all, on the basis of which it is mostly said that part of the profits should flow back to third parties. We are interfering and mediating merely for that sake of interference and mediation, without having to understand the other has the right to exist, the fundamental right. So, that is what is called equitable rights or equitable remuneration. So, it is in that context what the law says is that if there are persons having only equitable interests, means no legal rights, but equitable interests, and if their equities in all other respects are equal, then the judgment will be given on the basis of priority of time for a better equity for the remunerations or the compensation, whatever is there. So, these are the judgmental ideas having been well established in the eyes of the courts. Now, I told you about the access and benefit sharing issues. That is not the part of this frame which I am talking in this particular slide. This is about access to technologies or access to knowledge to the public. And there can be public domain products which are not protected by IPR, and there can be proprietary products which are protected by IPR. And if it is a public domain product, it is as good as a natural thing, plentifully available in the environment around you. So, that means commons. And if it is a proprietary product, then you can be excluded unless until you have taken the license, you cannot use it. So, that is called anti-common, that product is available, but not commonly available to you. So, what happens in such cases? In case of commons, there is a tendency to over exploitation, and exploitation is the word used when for its sustainability simultaneous reproductive efforts are not done or multiplication efforts are not done, like this overgrazed fields or the depleted fisheries. These are some of the examples given. And on the other side, for property products which are protected by patents or any other form of IPR, its non-availability to other for even further research hampers further growth and the development of technologies like these patents on genes or other life forms. So, there is a way out. Of course, our today's lecture is only telling you about the landscape, not arguing on what are the issues and what are the concerns or how to handle it, but still to say that if such situation arises, what can be the possibility to overcome it. So, instead of going in for the clarity of right, the content of property bundles means a person is having a patent on a gene BT, then he will try to have 20 patents on different versions of BT, so that he can use alternatively any of the version that is required or something like that. So, that is the purpose of writing content of property bundle. Now, how we develop a landscape? Because all information related to the grants, the IP titles granted or the patents granted, it is available in searchable data forms all over the world by different patent offices, and there are some public domain search engines and there are some paid search engines. The paid search engines, they claim to have done some cleaning so that you do not get roughages and undue data or duplicate entries. So, you can precisely work out as to what is the proportion of one area of technology and what is the proportion of the other area of technology if you have to negotiate with someone for any cross licenses. Now, what is cross license? Cross license is that company A has got 15 patents, company B has got 25 patents, but 5 patents out of these are on common technologies, common steps in getting to that technology, and they have to be still interdependent for 10 patents of one company and 20 patents of other company. So, if they are having ethical business and if they want to progress in their area of technology, then definitely they would like to negotiate with each other. Well, I have this, I give you a chance for trying this, you have that, you give that chance to me to try that, and tomorrow if we are able to come out with certain product, One thing, it is luck, you get or you lose because already there is a license, and second is they can still negotiate that at that time we will try to find out if there is any scope of a joint R&D, so that we can share the benefit accruing out of it. So, that means there will be scope. So, this is what you can get after understanding the landscape. So, that means all array is open before you, but there is a rule of the game, and within that rule of the game you have to play, and one area for that is that you have to search prior art. Means if there is a technology which is patentable, it ought to have been developed based on a technology for which knowledge was already existing, and an ordinary person in that field or in that discipline or in that art could have known that well whether this is obvious to him or something inventive or new has come out of it, right. So, that is prior art, and second is the legal status. Means after you have got the grant, whether the fees have been paid up, whether the ownership has not expired or expired, all these things having known that, then you negotiate with each other for cross licenses. So, you need to target your searches to hit the bull's eye. So, that part was a broader aspect of the landscape, right. Now, this institutional landscape, if we have to see, in this there have been so many international conventions and agreements which decided the course of institutional development in the management of various forms of intellectual property rights. And Paris Convention is said to be one of the oldest. I mean, in the written version, we can say here in this context, the oldest one having dealt with the industrial property rights. And industrial property rights in narrow sense contained patents, contained industrial designs and contained marks, which in the present day context we say as trademarks. At that time, it also talked of utility models. Now, patents in some jurisdictions take care of the utility models. There are separate set of rules or laws relating to that. In other jurisdictions, it does not take care of that. And similarly, inventor certificate, right of priority, unfair competition, these were the standard areas on which the negotiations were held, intergovernmental negotiations were held rather, and this convention settled down in 1883. And parallel to that, for works, literary and artistic works, for copyright and related right, there was another convention in 1886 called the Berne Convention. So, these are the, you can say, basic policy stimulants rather than the institutions. What is institution in that case, if I am not treating this as an institution, like the Patent Cooperation Treaty or the Madrid Agreement, these type of multilateral arrangements, intergovernmental arrangements which were made to give the benefits to the citizens of the member country for protecting their IPR in the jurisdictions of other member countries. So, these are the international institutional arrangements, I would say, precisely on intellectual property. Those are available, and from knowledge side, if we say WIPO is one, the World Intellectual Property Organization, which take care of all aspects of knowledge development in context of learnings and practices and skills on intellectual property rights. So, although the slide is very big and I can keep on explaining word by word so many things in that, but I will leave certain things to you as reading in your home, and if there is any question, we are here for next 3 weeks and the questions can always be there. You can think of the question, you can ask the questions right now. So, this is one aspect of the you can say landscape that I discuss with you. Now, the earliest date here is 1883. Why I have brought this next slide is the earliest date here is 1698, when this patent for crude engine by Thomas Sabre was granted. So, that means even though the international agreements were held subsequently, but the countries within their jurisdictions were practicing intellectual property protection. They were aware of it, there were means, mechanisms, and they were practicing. Like this, for barbed wire in 1873, there was a patent application and the owner was so much, I would say, पानी तो दे दीजिए थोड़ा सा पीने के लिए. अच्छा, he was so much aware about these things that after his first production and sales, what he did, अभी आ जाए, what है इसमें पानी है कि मुझे यहाँ से खाली लग रहा है ये बार बार, नहीं खाली नहीं है, पूरा भरा हुआ था इसलिए ऊपर तक दिख नहीं रहा था. आधा भरा तो अच्छा रहता है ना, उससे दिख जाता है. ऐसा. So, what he did was that in the first year of grant of his patent, he produced some 5,000 pounds of wire, which he recycled. He used entire profit to make a total some 5 times or more of the production. But in the second year, whatever the profits came to him, he divided into 2. Half of it he kept for the recycling part, means the production sales profits, and rest half of it he kept for legal fights. Tell me, in the developing world, anyone would think of these things at all? No. They will depend upon third persons to talk on their behalf and defend their cases. But when it is private right, the onus is on you. And with this mindset that US, which was having about 83% area in agriculture, about this point of time I am talking of, by 1883 or 1881, there was 83% area in US under agriculture. Now it is less than 3%, and that was the time when barbed wire was invented, and they came out from the semi domesticated, semi forest stages to cultivated stages, and then commercial agriculture and all. This cotton gin and spinning jenny, these patents are of the medieval era when Renaissance happened. You know the word Renaissance, many of you might remember some lessons of history in your preschool days. So, वो जो medieval period का क्या कहते हैं इंडस्ट्रियल रेवोल्यूशन था, during that period some revolution also happened in agriculture, and this is the result of that, and their mindset was legal oriented, intellectual property right oriented, and they knew that if we have to play the game of business, then we have to know our rules very strictly, very clearly, and to genuinely play that, and that is how they have progressed. So, it is better to you as messengers of this information to carry forward as to how to handle between activism and workmanship. This example is giving some more clarity on what I have just uttered, and after this medieval era, if you see the 1991 onward in US, the surge of transgenics, cotton transgenic came, and you see that even in the beginning of this present century in India, cotton transgenics came and transformation level. Although from the conventional you can say plant breeding, if you have to take an example, you can take an example of a single wheat variety in Indo-Gangetic plain which could cover more than 8 million hectare without IPR involvement at all, PV 343. But even for cotton transgenics, we do not have IPR on genes in India. We can only protect these materials by plant protection, or alternately this hybrids provide you a non-legal mechanism of protecting your original resources, because no one can imitate your product. If the you can say secrecy of the inbred lines is maintained. But these are some of the IP landscapes now I am talking, because I told you that if we talk of intellectual property, it subsists in the creations, as soon as the creations are made, whether these are works or these are physical assets. So, it is not intellectual property right. So, this confusion will keep on coming, and try to resolve during this next 3 weeks, so that you understand the difference between IP and IPR when you advocate it. Now, because TRIPS is an agreement, the trade related aspects of intellectual property right, which will always remind you the importance of trade. Why we are talking of IPR is because of the so called, if you say monopoly, let it be monopoly, and if you say exclusiveness, let it be exclusiveness, but that is the rule of the game. If you are in the business, you have to learn these habits very well. This example I am bringing from the period of Second World War. Two major things happened around the Second World War. One was Vavilov's voyages, where that Russian scientist went around the globe and collected more than 40,000 samples of different plant species, crop species and their wild relatives, and gave the concepts of centers of origin and diversity of crop plants. So, the area of plant genetic resources began. The second one is about the trade. Because heavy machinery was used during the war, they needed lubrication of that machinery to let it work well, and nothing less than the mustard oil was the best lubricant at that point of time. And Canada was dominating in the production of that mustard oil. So, after the World War, those industrial houses who have made huge profits during the war time, they got the slump, and they do not have any alternative where to sell their product. So, they have to bear with the loss. People say business mind is cunning mind also, let it be said, but at least they are futuristic and they were thinking for the future. So, what they did was that after bearing the losses for a few years, they tried to find fault with the existing product, that is mustard oil per se, brown sarso, and they said that it is having this erucic acid which is pungent, and this is giving bad smell, and this is having that badness or that badness. And then they made someone to do research on it, and by 1970s this product came out. And now, since it is an alternate product and they want to market it in such a huge way that it should dominate the market, first they thought of a name. What should be the name? First they gave the name Lear, L-E-A-R, that means low erucic acid rapeseed. But then their colleagues told, no, it will not be catchy and it will not catch the eye in the market. What then they thought of canola, and canola word has come, it is not a binomial nomenclature, it is not a botanical name, it is Canadian oil low acid. So, CAN OLA. This is the crux, I would say, the cunningness of the business mind. You can say the sharpness of business mind, and I would agree with you, and that is how the business comes forward. If you see some similar situation example from India, then this Lathyrus or Khesari, those of you who have been in the central heart of India, Madhya Pradesh or around or know about it, Khesari, because of Uttara system of cultivation, was the most preferred crop, because immediately as some rains come, they will just sprinkle the seed and seed will germinate at whatever cost. So, but now they have left this Khesari totally and soybean has come in. That lathyrine problem was there, because those who will not boil this pulse and eat it, there was a tendency of that lathyrism. So, finally, what happened here only at IRI in the biochemistry section, and Dr. Mehta, S.L. Mehta, his team, they came up with the 2 varieties having very low content of BOA, which causes that erucic acid pungency and all. So, they had not that, but low lathyrine. So, that means a product was available, but we were not able to push it to the market level, because we did not have our frame of mind, we did not have our IP mechanisms related to agriculture in place under, you can say, Patent Act 1970 and all, because product patent was not available to the life farms or agrochemicals. So, there were issues of that sort, but no one even thought of that if not in India, then I can try its production in some jurisdiction which will also grant me protection, intellectual property protection. So, these are some of the learning experiences which you will have from the landscape studies. I would say please try to understand that, but do not contradict anything, do not criticize anything. Let the water flow over your head, do not worry on that, because your concern and crux is to find something where that pearl is there inside that water, not that why others have not done this and why this could not have been done and things like that. So, that is the point where landscape study in the very first day was important for you. I give you an example of a landscape of a very developed mindset, where the developed side is able to do proper valuation of their intellectual property, because unless until you know the value of that intellectual property, you will not be able to do any commercial deal. And in this context, DuPont and Pioneer, they have gone in for a arrangement of direct payment of as much as 802 million royalty payment between 2014 and 17. Why? Because their assessors have been able to calculate that with the incorporation of that particular gene, which is otherwise expiring with the competitor company, they will be able to recover as much as 1 billion by 2023. Can any public sector system take that big risk? Cannot even dream of it. And what to talk of that? They are putting the liability for infringement even on the farmers, because the farmer is having no less than thousands of hectares of land on which a single product will be growing. So, Monsanto filed a case in Canada against the farmer, why he has not purchased my seed, and now I see in his field there is a material which is of my type, and the fact is that this rapeseed is often cross pollinated, and from the adjoining field pollen will come, and over the time you can have some plants of that type, and they kept on watching for a few years till substantial numbers of plants will accumulate which are of that type, on which they can make a lawsuit, and the court agreed to the appeal of the plea of the you can say company rather than the farmer. And what would have happened if similar situation is done in India? Our farmers who are having even less than 1 acre of holding, if they are subject to this type of rigorous you can say punishing by the seed companies, they will be nowhere. So, that is why some inbuilt you can say safeguard mechanisms have been given in the name of farmer right under protection of plant varieties and farmers rights, which you will know and understand in due course of time. So, this is the developed side story I am telling, and the developing side story is that, as I told you, we have protection of innocent infringement and under section 42, that is under farmers rights in chapter 6 of the protection of plant varieties, and also we have safeguarded farmers in our Patents Act under section 3H, where we still say that agriculture and horticulture methods are not patentable inventions. So, it is very ridiculous to take this or chew this sentence, but the fact is also that if there is a process which is a patentable process in the production of agriculture or horticulture produce, who will deny patent to that? No one will do. But by saying this as a statutory clause in the act, that means we have stubbornly safeguarded our farmers. So, that is the way jurisprudence will go, that is the way law of IPR will work. Then this traditional knowledge digital library outcome, that is also unique. It is a case of India study plus WIPO study, CSIR plus WIPO together. The wealth of India documents, those were first translated into soft copies, then they were correlated with the international patent classification, then the CDs developed out of it, these were shared under confidential agreements with the different country patent offices, so that the examiners there, they can examine the prior art in the during the search whenever a patent application related to use of biological resources of India comes to them. And based on that, now we have got substantial number of examples where either the patents have been withdrawn or the applications have been amended or these have been rejected. So, all type of situations happening. So, that means a clear cut proactive action has successfully meted out the requirements or the requisites. In the landscape, as I told you, innovation matters, invention matters and the grants matter. So, if we have to see the change in the landscape between 1996 to 2010, you find that China and Korea have jumped from nowhere. Korea is still visible to some extent in the 1996 that pink color, but China was almost negligible and now it has got a sizable space and touching the size of other leading countries. So, that means their mindset is clearly business like and they want to compete, their competitive ability is no way less, and this is also another part of the landscape that I wanted to share with you. This is something based on my own studies, that global patenting activities in animal vaccine from 1969 to 2009. If you see here, China with 35.32%, Russia with 22.21% and Japan with 19.18%. These are the leading countries as far as the animal vaccines, patented vaccines are concerned. And simultaneously there is a comparison with animal diagnostics from 1983 to 2010. And if you see, Russia maintains its position, China is much lower, Japan is much lower, but who others have come forward? USA and international PCT applications. Now, what is this about? This is construing your patent document and the canniness of the persons who have drafted applications for you, because when you talk of diagnostics, then within the context of diagnostics you can cover vaccine also. That if this is a problem solution relationship is there, if you take your complete specification in that fashion, then within that you can have certain vaccines included. So, whereas those three countries, they wanted to have the country specific vaccines because of the nature of the microorganism to produce that vaccine which is specific. They did not bother about the diagnostic part, but the other US and PCT holders, they are having the global business in mind, and they say, well, in the name of diagnostic itself we will sell our product of vaccines as well. So, this is something you can understand from the landscapes. This is although very little, very poor in India, but still this NP journal is national phase. NP mailbox is the mailbox arrangements, the applications filed between 1999 to 2005, which were kept pending for examination till 1/1/2005, till the product patent regime actually comes into place. And the third one, applications directly filed in India. So, these are the proportions in this slide. And if we have to have a patenting view on transgenics, check these two dates which I have searched myself. I mean, these are very simple things. Just put one or two keywords, search from the same database and see the temporal difference. There is no clearly cut record for transgenic as far as 2007 is concerned, but we have more nearly 13,000 patents granted on 2014, and in all other cases you are seeing the progress, whether it is clone, whether it is primer or marker or gene or probe, because these are different constituent steps when you have to develop certain transgenic. So, this is a landscape. In this context of transgenic, this is another part of my study, where I tried to see that in the mailbox arrangement, the PCT applications which were entered in national phase in India, there were some 400 applications that I came across. Out of these, some 90 plus were from the pharmaceutical sector, another 90 plus was from the animal science sector, and rest of these were from the plants. So, with those applications, I have done the analysis and seen the interest of various companies, various foreign organizations, universities to enter into India and to have their proprietary products in place, so that whenever Government of India declares a policy that you can enter into the business with the transgenics, they are having the upper edge. And this is a very old study, 2009, but still you will see that there were as many as 7 patent applications from 4 applicants covering 3-4 crops. Rice was there, maize was there, okra was there, and one was on detection principles only for transgenics, and there are other you can say PCT applications which were entered in the mailbox arrangement between 1999 filed in 1999 to 2005, but examined after 2005. Many of these applications the patents have actually been granted. So, this is another part of the landscape, and these are the companies or patentees I would say by category. So, foreign companies, foreign universities and all. Now, having said that, all what I discussed till now was an informal side of the landscape. Like till 1719, whatever plant breeding was done was an informal variability creation and selection by the farmers and their successive generations. But then you can say Thomas Fairchild, he developed first this artificial hybrid in flower, and that was the birth of the plant breeding called as formal plant breeding. Similarly, for formal or organized efforts in the tools for access to patent information or development of the patent landscape, there is a committee on development and intellectual property in WIPO, and a formal project was submitted by WIPO, and they wanted to have with these type of recommendations certain objectives built, and then in that application in which they sought for financial help from the world community was that they want to develop landscapes to be effective and useful format, right, with effective and useful format, and which should be concise and standard layouts and easy accessibility. And then also they pre-identified certain themes and topics for developing initial landscapes in various themes like health, environment, food and agriculture. Topics were given, subtopics were given and things like that. And what was meant from patent landscape in that case is that it provides a snapshot of patent situation of a specific technology either within a given country or region or globally. Now, you see, earlier also I have explained to you, but I had not defined it. That is the difference between the public knowledge and the legal knowledge. Whenever a legislation is there, always chapter 2 will give you the definitions or the interpretations of certain terms, and the judges will confine that all discussion between the two parties, fighting parties, based on that particular definition. So, that means if you are talking of a landscape and you are talking of an IP landscape which also is protected by patents, then you have this definition in place, and if it is IP, it will cover other forms of IP as well. So, this study also said that state of art search for relevant technology in selected patent databases, then analysis of search results to get answers to specific questions like patterns of patenting activity, who is doing what, in what field, where he is doing, things like that. Then patterns of innovation, what is the trend in innovation over the time in different jurisdictions, diverse solutions for a technical problem, then collaborations or individual efforts, then illustration of the empirical evidence to help understand and conclude some way forward. So, that means to encourage competitiveness. I have taken few examples here, and one of the examples here is, एक लेक्चर दे रहा हूँ मैं बात हाँ जी, मैं एक्चुअली एक लेक्चर दे रहा हूँ, थोड़े देर रुके, थैंक यू. So, why I have brought this is because water is a very you can say scarce resource, going to be a very scarce resource, and what polluted water is also a very big problem. So, some application can be made in agriculture field also. Very first thing that has been seen in terms of innovation is the membrane filtration UV disinfection and combination of technologies. And if you see top 5 origins means which countries, from which countries technology is coming, Japan topped for membrane filtration, but if you see the UV disinfection, then China, USA and Japan were almost at par. And most promising technologies, those have been patented, a list is already there. It is just to give a broader idea of the landscape. I am not going to discuss many things in detail, but this is giving to your own mind some irking as to think about the IP area in the fashion it should be thought of. You can develop your own papers, you can develop your own clues, whatever you want to do, but this is the basis why these landscape studies have been made. What I want to share a little bit as to why I chose this area. Application in desalination system. Now, salinity is becoming a big problem in the you can say surface water in agricultural fields, in the most productive areas in India. So, that means membrane filtration, UV disinfection and combination technologies will be very, very important to us. And if we talk of that, so that means we are talking of membrane filtration. So, indirectly coming to membrane filtration, here I must identify myself that I am a plant breeder, and in plant breeding there is one term called as nonsense correlation, and nonsense correlation does not mean that I am nonsense or I want to befool you. There can be some sense in deriving interpretation from that also, that if you cannot come out with a proper selection by any other